So I'm live on YouTube now. I am traveling. I am currently in Phoenix in a hotel. So one of the things that he points out, the felonies that they're committing by these in courts, 18 U.S.C. 153, embezzlement against the state. So remember, he said that what they're doing, they're engaging in aggravated identity theft, accounting fraud, concealment, securities fraud, tax evasion, embezzlement, and forgery. And so this is 18 U.S.C. 153, embezzlement against the state, personally described in subsection B, who knowingly, fraudulently appropriates to the person's own use, embezzles, spends, or transfers any property, or secretes or destroys any document belonging to the estate of a debtor, shall be fined under this title and imprisoned not more than 5 years or both. Person described in this subsection is one who has access to property or documents belonging to an estate by virtue of person's participation in the administration of the estate as a trustee, custodian, marshal, attorney, or other officer of the court, or as an agent, employer, or other person engaged by such officer to perform a service with respect to the estate. And I guess that's about it. Yep. So you can see how that ties into the estate. So what we have now is this attorney's handbook of accounting, auditing, and financial reporting.
What is meant by aggravated fraud or aggravated identity theft?
Well, you have to look that up. Quite frankly, I'm not. This is something I'm in the learning curve about. But he's calling it aggravated identity theft, and I think it is. But aggravated. So identity theft. So they're stealing your identity so they can pillage. So it's to engage in felonies. I would say it is to engage in felonies. But I would say you ought to look that up or go and watch some of his videos. There's 2 videos that I've uploaded, links to 2 of his videos on his that have both been uploaded. They're on links, or both of them are on the Telegram channel. So anyways, this is taken from the LA County Law Library.
So then aggravated can be in that instance can be defined, or it means doing something with ill intent in commission of felonious activity or something like that.
Yeah, I would say it probably does, but you need to find out for sure. I'm certainly not an expert. I'm just rehashing what Todd went through or explained. Matter of fact, this is actually taken from that attorney's handbook for accounting, auditing, financial reporting. And there's 17 pages that are here, so I'm guessing that it's not the whole book. But it says the attorney and the accountant must be certain there's no real or perceived conflict of interest in the accountant's involvement with the attorney's case, regardless of whether the accountant serves as an expert or a general consultant. There are numerous bases for such conflicts, but perhaps the most common is that the accountant may have a prior or a current business relationship with one or more of the parties on either side of the case, including the attorney. Once the attorney is informed about a relationship, he can assess whether a conflict of interest exists, either in fact or perception, which is interesting. Some cases, the attorney may prefer that communications with the accountant be oral for the most part, and others, a formal written report of findings or conclusions from the accountant will be desirable, or even by the trier of fact. The structure of such a report is usually flexible as long as the essential information is included. For example, effective December 2010, there were comprehensive revisions to the Federal Rules of Civil Procedure, including changes to Rule 26A2, which governs disclosure of expert witness testimony. These changes included that drafts of expert reports are generally no longer subject to discovery, and protections for communications between the party's attorney and any witness required to provide a report in that effort to improve on the quality of answers to interrogatories. The expert in a federal case must now submit a written report that will contain at a minimum the following elements. And there's a bunch of them there. When CPAs perform audits or reviews of financial statements, help clients with forecasts or projection of future events, or render attestation reports on any of a broad range of non-financial matters, they are guided by established sets of professional literature. That's called generally accepted accounting principles. So anyways, this goes through it. It's kind of interesting. Investigative accounting. You know, there's a guy that comes on that we've had on our channel, on my YouTube channel. His name's Ron. I can't remember his last name. He's a forensic accountant, and
Ron Adams.
So, Ron Adams.
Yes, he has a page in here as well.
Yeah. So he'd be a good guy if you wanted to build a case, you know, to get him to help you. Financial fraud and other forms of so-called white-collar crime cause great concern in the United States. Accusations of illegal acts and management malfeasance can lead in turn to matters for which attorneys may seek the assistance of independent accountants. As a general rule, most of the highly publicized cases of corporate criminal actions, such as misappropriations of assets, occur in the following circumstances: when dishonest officers or employees have the ability to circumvent the entity's protective controls, which may or may not be otherwise adequate, or when two or more perpetrators collude, which can weaken the protection afforded by the controls. So then, if you think about it, so there's a conspiracy between the clerk and the judge and the prosecutor is what's really happening. And so they know about this stuff. The independent accountant's knowledge and skills in business accounting, information systems, and other related matters enables him to assist in the systematic examination of financial aspects of illegal acts. For example, a thorough understanding of auditing and accounting permits the accountant to understand and quantify an alleged fraud, while the attorney concurrently addresses the underlying law and legal strategy of the case. Once refined, these investigative accounting skills may be used in many similar situations, including asset management, disputed insurance claims, problems involving computer applications, money laundering, bribery or kickbacks among vendors, contractors, purchasing agents, and customers. The term forensic defined as belonging to, used in, or suitable to courts of justice, public debate, or formal argumentation, has been applied increasingly to the consideration of accounting concepts in a wide range of legal matters in recent years. Although forensic or investigative accounting is a relatively new way to describe this area of practice, the services that are included within its scope are to a large extent those that independent accountants have been refining and applying for decades. Fraud and the auditing process. The alarm bell that indicates a fraud or similar financial misdeed may be sounded as a result of something discovered in the course of the annual financial statement. Audit, a tip-off from an informant, okay? Example, when you file a Form 211 whistleblower form with IRS, or the chance discovery of an irregular transaction in accounting or financial records. Accordingly, the design of an approach to determine the size and economic impact of the problem depends on a variety of accounting and legal factors unique to the circumstances. See discussion of fraud issues in Chapter 12. Thus, there is no single method for investigating an alleged defalcation, misappropriation of funds, or other financial misdeed. Moreover, despite the general inclination by non-accountants to consider an independent accountant's involvement in such a matter to be an audit, as discussed in Chapter 12, the accountant is rarely engaged to perform an actual audit in accordance with generally accepted accounting standards. Likewise, the application of generally accepted accounting principles is often not a principal concern unless the alleged illegal activity or action is so financially significant that it would result in a material misstatement of the entity's financial statements taken as a whole. When an accountant is first engaged to conduct an investigation, he may have only the vaguest idea of the problem and how to address it. Accordingly, the accountant must learn about the nature of the entity, determine the relevant facts, and collect as much pertinent data as possible. Key areas of focus are the entity's internal control systems and the accountant's determination of the extent to which those controls may have been circumvented or overridden. As a starting point, the accountant's knowledge of general business practice and operations within specific industries typically alerts him to situations or events that seem abnormal and indicates potential problem areas. Certain industries may be at particular risk for certain types of fraud. The insurance industry is sometimes subject to fictitious claims or overbilling by customers or employees. Thus, the accountant's knowledge of specific industries and the ways they conduct business may be very important. An analytic review of account balances may also be a valuable first step because it highlights balances that fall outside a normal or anticipated range. As a result, questionable transactions may be identified and the underlying documentation for those transactions can be reviewed. For example, in one investigation for the attorneys for an advertising agency, a certified public accountant compared actual costs to budgeted amounts and found that certain expense categories increased substantially in a new project manager's department. The expenses were often compared to source documents, revealing that many invoices allegedly received from different suppliers were apparently prepared with the same typewriter and that they had not gone through (16-19). I guess we missed that page. 16.4, and 16-30. Anyways, so this is all stuff that that's in the attorney's handbook of accounting. And so, and then you're actually, it's actually, well, I wasn't sure if I should bring this up or show this, but he went and had it. He went and showed it in his. This is what they did over a. They arrested him. Maybe I'll just go ahead and show it. They arrested him. I think it was a traffic violation. And this is the CUSIP that was pulled up. A booking number. CUSIP. This was on the 1st of April of 1996, I guess. Worth $380 million, $235,000 as of 10th of October 2025. So this is the kind of stuff you find out when you start getting an accountant looking for stuff. $380 million. So, you know. So it's all important. I'm telling you, these courts are basically you got to start bringing that stuff up, and that's what he talks about in that Word file that we went through last week and that I uploaded to the group. And I would suggest that people get familiar with that stuff and start bringing that issue up. I bet your court case will go away, and you might even get some money out of it. And maybe you can get some judges fired or removed or in jail. Judges and attorneys. There's some that I'm working on, but I don't want to talk about that until I see them get arrested. Then I'll talk about it. What I'll do is I'll upload this to the group. So I'm uploading two. There's 18 U.S.C. 153, embezzlement against the state, and the attorney's handbook. So I know this is kind of short, but does anybody have anything else you want to go through? Any questions about anything else we did in the past? Not a lot of people listening in here, so I guess that'll be about it. I'm just looking on YouTube. Says you have to have an affirmative finding for aggravated identity theft. That's possible. It's like that Jewish show X Factor. They're all in it. Yeah, you never
What
know.
does that what does that mean? I'm sorry. A finding a finding for aggravated identity theft.
Well, I think a lot of it is just allegations. In other words, you accuse them of it and let them defend themselves. You know what I mean? It says, but an
Yeah,
affirmative.
the accuser has the burden of proof, though, right?
Not when you're in that. Okay, the IRS. Think about it. You're dealing with the IRS. So now all of a sudden, if they're engaging in aggravated identity theft, okay, or tax evasion, okay, well, that becomes breach of contract. So under the IRS, you don't have any constitutional rights. Now, it's not you in this case, it's them. And now you're actually, if you take them into tax court, you're on behalf of United States take them into tax court because they went and took some money out of that Treasury Direct account, and they should pay taxes on that. You see what I'm saying? So now the U.S. attorney is working for you, and it's all part of a United States versus Joe Blow judge or Joe Blow attorney or Joe Blow district clerk. You see what I'm saying? And they know they're guilty as shit. And so, but that's the question. You still got to build a case, but it's completely different scenario. I mean, you've dealt with IRS, I'm sure. So it changes quite a bit because it's part of breach of contract, and so that contract gives up constitutional rights, and it's their they are engaged in breach of contract. So it's a little bit different.
On the grounds that they are public servants or public trustees, and they are causing undue harm and injury on their
Exactly,
beneficiaries.
and they have an oath of office and a whole bunch of things that they're in breach of. I mean, a whole bunch of things, and so it goes back to the old story. They put Al Capone in jail for tax evasion. So, anyways, yeah, it's quite a bit different. And you're attacking them, and their due process is a lot different than under the Constitution. Remember that U.S. citizens don't get access to the first 8 amendments of the Constitution against the powers of the federal government. There's lots of court cases that talk about that. That's the fictitious entities, okay? These judges, when they're sitting in that office, they're sitting there as a U.S. citizen. They have to say under penalty of perjury they're a U.S. citizen to even have that office. So it's a lot different. Anything else from anybody? We can keep going through this attorney's handbook if you want. But I uploaded it to the group, so you can get it from there, and you'll see the stuff that's underlined. There's 19 pages of it that's here. And these Ron Adams, I've listened to some of his presentations. He's a pretty sharp guy, and so I'm sure that he's certified forensic accountant, so he knows what to look for, and you know knows where to find it. I'm sure. If you read last week, we went through the instructions for the 1099A, and it says right in there that courts have to file a 1099A.
Because they are acquiring a so-called abandoned property, or is it in their instance, is it for acquisition?
Well, it's not abandoned property, first of all, and they're forging your signature onto a 1099A, a bid performance and payment bond. On 3 bonds, they're forging your signature. What they do is they just print it there. They don't even try to sign it. They just print it. Print your name there. That's all they do. And put you down as the debtor when actually you're the creditor. And so you have to do I don't know, you have to listen to Todd, because he tells you have to do a 1099C, I think, to correct it. And what you do is you what's the word? You revoke and revest, okay, the signatures on those all securities related to that transaction pursuant to 26 USC 671 through 677. And so you revoke and revest those securities, and all you have to do is say that, and now all of a sudden, if the problem doesn't go away, then they're exposed. Then you just have to, you can easily build a case against them for embezzlement, tax evasion, forgery, et cetera, et cetera.
When they do those A's, they're is pursuant to the acquisition part of that A, right?
The 1099A?
It's the A stands for acquisition and or abandoned property. So they're probably coming in as the they're doing like an acquisition of the abandoned property, because acting like you didn't abandon your your fiduciary responsibility
I
to be
don't know.
managing it.
I have, there's a lot of people saying that, that A is for abandoned property. Let me pull up that instructions.
All of those, the letters stand for something, and so it's like ABCs. It's real, comprehensible if you know your ABCs. The A stands for acquisition, and it stands for abandoned property. The B stands for barter or broker. The C stands for cancellation,
Well,
maybe, and or correct.
could be, but they're putting you down as the debtor, and that's wrong. And Todd explains why that's wrong. And so this is the form. You're right: acquisition or abandonment of secured property and cancellation of debt. So the C is what you do to cancel a debt, so the A and C, acquisition or abandonment of secured property and cancellation of debt, they're making you the debtor. They're just forging your signature. That's forgery.
Well, and then so the way that they're coming in is important. They're acting like they are Almost kind of like they're the debtor because the debtor is in debt to us. And then when you look at the definition, I believe it is on the A, right there in the instructions. It defines debt. It is an amount you believe is owed. So what's important is how they're coming in. They're coming in to acquire the abandoned property. That's what they're doing.
So, anyways, it's of a debtor, first of all. Cancellation of debt. And so you change it to you're the creditor, and that's why you have to revoke and revest it. And the court or administrative office files this thing. I'm not exactly sure how you do it, but all you have to do is really just tell them to set them up. Is tell them I revoke and revest all securities associated with this case. That's all you do. That's all you tell them that. And and once you tell them that, they all of a sudden got a problem. Anyways,
You know why? You know why? Because
because you're
because you just busted them. You just caught them in the identity theft because they're filling out those forms as if they're you. That's why.
exactly, exactly, exactly. So, anyways, um, I guess that's going to be about it. Um, I would suggest they put out one of those videos. They actually it looks like they broke that video down into four videos, and so they published one of them. And these documents. There's three of them, four of them actually. Let me go back there. We went through the arrest and investigation survival guide last week.
That sounds robust and juicy. We missed that one.
I went through it last week and it's uploaded to the group, so you're welcome to go through it. What I did is I took a bunch of stuff out of it and made a bill of particulars.
Ah,
But I would suggest you get familiar with that stuff because I think that's what's going on. And you can, first of all, if you bust them doing that shit, if you catch them and break it off in their ass, next time they see you, they're gonna find somebody else to fuck with. They're gonna tell all their screen for low intelligence thugs to go and find somebody else to screw with. You see what I'm saying?
yep, because they can't afford you. Haha, your booty costs too much, and they looking for cheap hoes.
That's right.
They looking
So
for cheap tricks.
yeah, well, they're just nothing but a bunch of thieves, is what they are. Don't get me going. But um, so you can. This is how you break it off in their ass. And what you can do is you do the CUSIP search, and so then you pull it up by the CUSIP number because everything gets a CUSIP number. Anyways, I think that's going to be about it. Does anybody else have anything else?
No, but thank you so much for your time.
Sorry?
I said thank you so much for your time.
Well, not a problem. This is a networking thing. I don't know everything. And so that's why it was good to be into this discussion that we were talking about earlier and spread the word. The more people that break this off in their ass, then the less likely they're going to be fucking with people. Because
Exactly.
right now the courts are very corrupt.
They always have been. And there's nothing new underneath the sun. They always have been.
They're a lot worse right now than they have been in the past, I think. Everybody sees
Oh, yes, for sure.
So we'll see you next week. Same time, same place, same channel.
Thank you so much.
All right. Peace out.
You bet. See ya.